Rise.
That's it. My Lords, the relevance of rectification and then ex parte James. Could I invite your Lordships to pick up the appellant's notice behind tab 1 in the core bundle A17. And it's paragraph 4, and in particular, I know your Lordships will have read this C. Inappropriate on a strikeout or summary judgment application for the court to determine that the administrators and or Clyde Co are entitled to rely on an interpretation of the agreement which is inconsistent with the assumed basis, or to do so pending determination of any rectification claim which may be made by a party to the agreement. As your Lordships will have seen, on the 20th of April of this year, proceedings were issued against Barclays for rectification, and by consent those proceedings have been stayed without being served pending the outcome of this appeal. The point here, number 1 point here, my Lords, is this. The current proceedings, which at the moment are struck out and are subject to this appeal, are time-barred, in the sense that if they remain struck out, we will not be able, under the Limitation Act, to issue fresh proceedings in due course, should the rectification proceedings be successful, and remove the ability of these defendants or respondents to rely on the agreement. So that what I'm addressing here is essentially a procedural point. Let's assume for a moment that as a matter of substance, your Lordships are against my clients, as it were on everything else, so that you uphold the judge's reasoning on the, may I call it, unrectified agreement. On that footing, the gist of what we are submitting is it would be unfair and wrong in principle on a summary judgment strikeout basis to allow these proceedings to remain struck out, notwithstanding the fact that if the rectification proceedings are successful, they will have been struck out on as it were, in the events which have happened, a wrong basis. There is also the difficulty that if they remain struck out, we will not be able to start proceedings afresh due to the limitation problems.
So, 2 questions. First of all, how can you rely upon your rectification claim, given that this is an appeal against the judge's order, and at the time he made his order, there was no rectification claim? Second question, you say it's all jolly unfair, but why is it unfair when you had 3.5 years to issue and bring to a conclusion your rectification claim before you issued these claims?
Well, the paragraph 69 of our main skeleton argument addresses the second question, and that is that we could not have foreseen that the settlement agreement would be construed in this way. Indeed, we don't think Barclays construed it in this way when they insisted that certain persons entered into confidentiality terms, which, if my own friends are right, was unnecessary because they were affiliates. And it was only relatively recently that the point was raised in these proceedings based on the settlement agreement, and it was inevitable that we would at least see what the court said the settlement agreement said before deciding whether to apply for rectification, which is precisely what we did. We couldn't really
backward. I mean, I understand your submission about why you didn't bring rectification proceedings prior to these ones, You accept that the issue was raised at any rate in November 2020, So you could have issued rectification proceedings there.
Well, my Lord, we could, but for what it's worth,
And the judge's judgment was given nearly a year later.
Yes, it was, and no one has been prejudiced by a subsequent delay because this appeal was pending in any event, and the premise is that your lordships are against us on our construction of the unrectified agreement. So it was reasonable for us to wait to see if our appeal is successful, but we have nevertheless issued in the meantime, not least to show that there's a pleaded claim for both common mistake and unilateral mistake, based on the same materials that were before the judge. And the judge himself used the possibility of a claim for rectification as a ground for saying that it was not unfair to exclude Mr. Schofield's evidence. So in one sense, the appellants are damned if they do and damned if they don't. Certainly the judge envisaged that we could apply for rectification, and that was our proper remedy, that was his judgment. We have appealed against that, but in the meantime, because it has now been said against us that you should issue rectification proceedings, we have done so. But our submission is it was reasonable for us to wait for this process to complete to see whether your lordships agreed with the judge or disagreed with him, because if you disagreed with him and found that the agreement says what we say it says, then we will have wasted time and money in seeking rectification. And in all the circumstances, that it would be somewhat infested with hindsight if it turns out that your lordships are at least as strongly in favour of my own friend's interpretation of the agreement as the judge.
Why you would waste any time or any money if Barclays agreed to your rectification claim?
Well, my lord, it's early days. I mean, at the moment, they have said that they are going to...
I think it's inherent in your submissions that they're going to resist it tooth and nail.
Well, my lord, they might well, but these things flex and they move over time, and it's very early days.
And if they do resist it tooth and nail, that might cast some light on what weight should be given to Mr. Schofield's evidence, apart from anything else.
Well, my lord, to be absolutely fair for a moment to Mr. Schofield, I mean, no one yet suggested that they've even consulted Mr. Delahunt, who is the individual within the bank, or was, who was, as it were, facing Mr. Schofield and making the statements that he did. And crucially, also, he was the person at the mediation. We have no indication at all that Barclays have gone to him at all and put to him what's being said. And in the way of these things, when simply Mr. Schofield is very clear about his position, and it is not fair to Mr. Schofield to assume that his position is not going to be vindicated in due course, not at this stage.
You actually asked Barclays?
We sent them the particulars.
Or to be sure, but normally you send a letter before claim at minimum. And indeed, in these circumstances, one might have thought that a simple inquiry, do you agree with our interpretation of the agreement?
I think we have asked them, my lord, yes, and that they don't.
Right.
But what we don't know, what we don't know is whether they have consulted the individuals, whether they even still work for the bank, within the bank, who are said to have reached the accord or the provisional concurrence that we allege.
Just on that point, I see that you have included correspondence with the bank.
Yes.
And in particular, the letter of A478.
Yes.
Where the bank aren't agreeing.
Indeed. But what as I say, the only point I'm making is we don't know at this stage whether they have gone back to the employees who were actually in the mediation, whether they've done what one has to do in order to see factually what the position is. Yeah. But with respect, we would suggest that the fact that the bank is wanting to defend the proceedings is not relevant to the principle. And I accept, my Lord Justice Arnold's point that at all times they have the contractual right with us to agree to rectify. I accept that. And in our skeleton argument, we do make the point that its situation is akin to the party in the position on this premise of having had his established that his claim does not pass muster, but is given an opportunity to replead its case if it is thought that that is a reasonable possibility. In the same way, we say the appellants on this basis should have the opportunity to elect whether to join Barclays and seek rectification, or just to pursue Barclays in separate proceedings, and that these proceedings be stayed in the meantime. Otherwise, we would say it does work as substantial injustice to Mr. Schofield and his companies. To put it another way, and I'm an eye on the time, my lords, if your lordships were against us on the challenging the reasoning and conclusion of the judge on the interpretation of the settlement agreement, and you were upholding his reasoning in effect, in substance, then we would invite you to allow the appeal by setting aside the striking out order. But we would accept that the proceedings would then be stayed pending the final determination of the rectification proceedings. If the rectification proceedings are not successful, then that's the end of the matter. If they are successful, then we will not have then a res judicata in relation to the strikeout. That leads me in the time available to ex parte James, and that is, as you will appreciate, rounds 5, 6 and 7 of the skeleton argument. The exchanges that we've just had about time bar and so forth are relevant to ex parte James as well. So just staying with that for a moment, if it is right, if we assume at the end of the day that the rectification proceedings are allowed to proceed and succeed, we say it would be wrong for the JAs, joint administrators, former joint administrators, to rely on matters as they currently stand, if you're against us on this appeal, knowing that those rectification proceedings were pending, knowing that they were on the basis of common and or unilateral mistake of the parties. Because they are being sued in misfeasance proceedings for contribution in respect of their conduct as administrators. And we say that they would not be allowed, under the rule in ex parte James, to defend by relying on an agreement which might be rectified. And if it is rectified, it would be wrong in principle for them to take any benefit from it.
This, of course, is again not an argument put before the learned judge.
Well, this argument comes out of the, that is right, this argument comes out of the issue of the proceedings. But one ends up in a situation where if the proceedings stand struck out, they have successfully defended proceedings which are designed to conduct an investigation into their conduct whilst administrators with a view to them making a contribution by reliance on an agreement which, in the events which have happened, is not available to them as a defence. And that, we say, is a good example of the operation of ex parte James, notwithstanding their discharge from office. Because the court would have before it its officers, albeit former officers, an investigation into their conduct whilst they were officers. And in those circumstances, the court would not allow them, if, for example, the agreement was found to have been completed as a result of a unilateral mistake, sharp practice, to rely on that agreement. But my lords, in the court below.
Can I just think on that one moment? I mean, suppose the rectification claim succeeds, then there's no need to say they can't rely on the unrectified agreement.
Not if they're already struck out, my lord. If the proceedings have already gone.
So, would the sharp practice? When would the sharp practice arise? Would it be in circumstances where they took the limitation point?
No, my lord. The sharp practice was a reference to the unilateral mistake.
Yes.
Objectively unfair on the Lehman test. It would be objectively unfair to strike them out now, strike out the proceedings against them now, in circumstances where it could in due course be clear that the grounds for the striking out cease to exist.
And just pursuing it a moment more, supposing that to be right, you say, well, the problem we face in relation to the rectification claim is that by the time it's resolved in our favour, it'll be too late.
Well, if your lordship simply allow the appeal on this premise, and the proceedings are struck out, they're struck out at a time when we're time barred.
Yes.
And it's a res judicata.
Now, I follow that. I'm just wondering whether a different way of looking at ex parte James would be, well, at that point, supposing there to have been sharp practice in relation to the original agreement, it would be that the administrators couldn't take the time point when you issued new proceedings.
But that's a risk we're not prepared to take,
No.
because there's obviously a lot of time and money going to be involved in the rectification proceedings, and that degree of uncertainty would be unacceptable with respect.
Yes, I see.
If, on the other hand, the parties were to agree not to take a limitation point in any new proceedings, that would be different. But otherwise, we stand time barred.
Yeah.
Your lordships have our submissions as to why what we call the accident of timing should not affect the applicability of the ex parte James rule. And may I suggest that, given that you have our written submissions, and also you're going to hear from Mr. Smith on the subject, you hear from me in reply on that, just so as to adhere to the timetable?
Yes.
We also, as you know, submit that there is a real issue here about the relevance of the statutory scheme for discharge of administrators. This is our ground 6. Where we say that the agreement that they wish to take advantage of, if it means what they say it means, gives them a wider release than the release that Parliament has determined is appropriate. And that we say the judge was wrong to hold that was irrelevant, not something that should be considered on the application of the principle in ex parte James. And my lords, for the reasons that are set out in our skeleton and indeed our grounds, we say that ex parte James was both applicable here and should operate to prevent these joint administrators from relying on this settlement agreement on grounds of objective fairness within the meaning of that phrase in the judgment of Lord Justice David Richards in Lehman Brothers. And that, at the very least, that issue is something which is properly for trial and not for a strikeout or summary judgment application, because it's multifactorial and it requires an assessment of all the facts, including the nature of the reasons for rectification. Those are our submissions in opening.
Thank you very much. Mr. Smith.
Thank you very much, my Lord. My Lord, if I can just begin by setting out the framework to our argument. If your Lordship go to paragraph 8 of our skeleton argument, which is in the core bundle behind divider 6, page 91, we've set out the core building blocks, and the position is, we say, perhaps unsurprisingly, very straightforward. First is, by the settlement agreement, the company's released, quote, any claims against any released parties. And that's clauses 2.1 and 3.1. We'll obviously come to those in a moment. The key concepts are the definitions of claims and released parties. Second building block, the claims brought against the former administrators in these present proceedings fall within the definition of claims. Now, there is no dispute about that. The judge recorded that at paragraph 77 of his judgment as being common ground. And my learned friend hasn't taken any issue with that on this appeal before your Lordships. So it's common ground that the claims in these proceedings are capital C claims. Now, the third building block where there is dispute, and which I'll obviously address, is whether the former administrators come within the definition of released parties. But the fourth building block, former administrators are entitled to enforce the operative provisions of the settlement agreement under clause 8.1. There's no dispute about that on the assumption that we're right that the former administrators are affiliates. And that's the effect of clause 8.1 of the settlement agreement. Again, the judge recorded that at paragraph 65 of his judgment as being agreed. And then the final building block, again, this is not disputed, but just so your Lordships have the position, is the appellants bring these proceedings as contributories of the companies. Procedurally, they bring the proceedings as contributories, but it's common ground that they stand in the position of the companies and they can't assert claims on a cause of action which the companies themselves no longer have because they've released it. And again, the judge recorded that in the judgment, paragraph 68, as being common ground. So essentially, the sole issue concerns the third building block and the question of whether the joint administrators and former administrators are released parties. Now,
Mr. Davis puts it two ways, I think. He has a definitional point
yes.
about released parties, and he has a point about whether it's other released parties.
Exactly. So I was going to deal with those 2 points in turn. The first I've called the two camps argument, because I think that is how it's referred to, at least from time to time, in the skeleton. And then the second is the employee argument, or as your Lordship says, the definitional argument. And I was going to deal with those in turn, starting with the two camps argument, as I call it. And as your Lordship says, this is the argument that the settlement agreement doesn't affect releases of claims by either Barclays or the Rhino companies against their own affiliates. Now, in our submission, the major problem with the two camps argument is that although it's ostensibly put forward as an argument of contractual interpretation, it cannot actually be reconciled with the language of the settlement agreement. So if we turn to the settlement agreement, which is in divider 25 of the core bundle, and perhaps start with the first of the substantive provisions, which is clause 2.1 on page 448. Clause 2.1, this agreement is made in full and final settlement of all claims any party has or may have against any other party or against any other released party. Now, if you go to the definition of released parties, which is on the preceding page 447, that captures the parties and the affiliates of the parties. And you know, in turn, the definition of affiliate in turn includes employee, and then employee captures former, present or future directors, officers, employees, shareholders and agents, and so on. But if we just stop at the definition of released parties, under clause 2.1, any party is settling any claim it has against any other party or any other released party. Now, as a matter of straightforward language, that releases any claim which a party has, firstly against another party, secondly against an affiliate of any party, including its own affiliate. And there's no ambiguity in clause 2.1. And indeed, I didn't understand my learned friend to put forward an argument on the construction of clause 2.1. He did have an argument on the construction of clauses 3.1 and 3.2, which I'll come to in a moment. But I didn't understand him to put to your lordships, as part of the two camps arguments, a case on the construction of clause 2.1. Now, you then come to clause, we can, I think, ignore clause 2.2 for these purposes, which deals with the discontinuance of the action. But you then get clause 3, which is headed covenant not to sue. In fact, clause 3.2 is the covenant not to sue. Clause 3.1 is a release and discharge provision. Now, clause 3.1 states each party agrees that the released parties are released and forever discharged from all claims. Now, my learned friend's approach here was to assert that it doesn't work as a matter of literal construction, and that you need to insert the word other in front of released parties, and that provided a springboard for the argument he then made, which I'll come to in a moment. But our primary point on clause 3.1 is actually you don't need to insert the word other in front of released parties at all, and it works perfectly well read literally. Now, it's obviously expressed in terms of being like a declaration. It's sort of declaratory as to what the agreement is intended to achieve, what it does achieve. But it's perfect, makes perfect sense to say each party agrees that the released parties are released and forever discharged from all claims. And the released parties, again, includes all the parties and all the affiliates of the parties. So there isn't, in our submission, any need to add in any additional language into clause 3.1. I accept that in paragraph 118 of the judgment, the judge effectively said you could look at it both ways. You could either add in the word other, alternative you didn't need to. In my submission, it's the second of those, which is the correct approach. There isn't a need to add in any language at all. Now that then takes one to clause 3.2, which is the covenant not to sue. Each party agrees that it will not bring proceedings against any released party. Now, I accept that if one is being perhaps a little technical about it, one might say the draftsman ought to have added in the word other in front of any released party, in the sense that, as my friend says, you can make the point that as a matter of law, a party can't sue itself. In my submission, that is not necessary to make sense of this agreement. As a matter of a counsel of perfection in terms of drafting, one might add that word in there. Now, my learned friend, as I understand it, using that as the springboard, the insertion of the word other, then seeks to say, well, you add in the word other, and then you go to the definition of released party, and you add in the content of that definition, and that leads you to the conclusion that that reads, or should read, any other party or affiliate of that other party. Now, two problems with that in our submission. The first is there's simply no basis. There's a leap in the logic there, because all the word other is designed to indicate is that a party agrees that it will not bring proceedings against itself. That's the only reason you need to add in the word other. That's the sole basis for adding in the word other. It doesn't provide a basis for then excluding from clause 3.2 suing any affiliate of that first party. So in our submission, there's a non sequitur in the logic. But secondly, there's a more convincing answer, even more convincing answer to that, which is that if one accepts that the draftsman was over-compressed in the first line of clause 3.2 when he simply said any released party, it's obvious that what he was over-compressing is the fuller exposition which you get in the second line of clause 2.1. And that the phrase which he was compressing, arguably over-compressing, although I wouldn't necessarily accept that, is the phrase set out in terms in 2.1, which is any other party or against any other released party. And as I submitted, that captures the affiliate of any party. And my learned friend accepted, as I recall, that as must be the case, that you need to read these provisions consistently with each other, and that clause 3 would fall to be read consistently with clause 2.1. So, just pausing there, in our submission, there's no ambiguity in clauses 2.1 and 3.1. There is perhaps a minor defect in the drafting of clause 3.2, and that doesn't lead to my learned friend's construction, and in any event, the better way of reconciling that defect, if there is one, is to construe the clause in a way that conforms with clause 2.1. Now, my learned friend's other point on clause 3, as I understand it, was to refer to clause 3.4. And we'll come back to clause 3.4 because this is also relevant to the question of commercial purpose and the way in which one goes about releasing ricochet claims. But at this stage of the argument, I understood him to be making a different point, which is effectively to say that clause 3.4 only works on his two camps argument, that you can't read it in a way that makes sense unless you adopt the two camps argument. In our submission, that is simply wrong for the reasons which the judge himself gave in the judgment at paragraph 121, which is tab 12 of the core bundle, page 183. I don't think I can do any better than on this point than refer your lordship to the judge's judgment. So I say it's towards the bottom of page 183. As regards clause 3.4, Mr. Davis submits that the clause does not contemplate and would not operate if the first party, as they're defined, is sued by its own affiliate. I accept that the clause only bites in the situation where an affiliate of one party, party A, brings proceedings against any other party, any of parties B, C, or D, or against any of that other party's affiliates. And that's obviously right, that's what the clause says. I do not, however, accept that the clause bears out the two camps theory. On its natural reading, any of the Rhino settlement companies could be the first party, and if one of its affiliates brought proceedings in relation to a claim against another Rhino settlement company, then on the face of it, that other second Rhino settlement company could rely on clause 3.4. And that's effectively the answer. He then goes on to say, I don't accept in any event that the clause is inconsistent with a party releasing its own affiliate under the other provisions of the settlement agreement. Clause 3.4 is dealing with a particular situation, that of a party bearing some responsibility to avoid the consequence that its own affiliates have not themselves released claims against other parties. But in our submission, the judge is absolutely right when you look at clause 3.4, in that it would preclude an affiliate of one Rhino company bringing proceedings against another Rhino company or against an affiliate of another Rhino company. And in fact, the clause 3.4 not only doesn't provide any support for the two camps theory, it contradicts it, because that scenario which I've just posited is plainly one that is open and contemplated by the wording of clause 3.4. Now, in our submission, there ultimately isn't any ambiguity in this agreement. It's clear as a matter of language. One might add to those points another point, which is that if in our submission, if the parties had intended to carve out claims against the former administrators or their legal advisors, there is an obvious way in which they could have done this. And can I take your lordships back to the definition of claims, which is in page 446 behind divider 25. I'm not sure we spent much time looking at the definition of claims, because as I say, it's not in dispute for the purposes of my friend's appeal on interpretation. But if you go to the bottom of 446, you can see it's defined quite broadly by reference to the facts and matters pleaded in the pleadings in the Barclays action. But then if you go over the page, it's interesting to note in our submission the antepenultimate, penultimate and final lines, because the parties did carve out a particular claim which they had in mind and which they plainly contemplated or plainly intended wouldn't be released. So one can see actually that the parties did apply their minds to the idea, well, do we need to carve anything out of this agreement? They identified one claim, and that's how they did it. Now, it's interesting in our submission, just whilst that's in one's mind, to look at how my little friend is putting his claim in the rectification proceedings against Barclays. Because if you go on in the bundle to divider 27, you have the claim in the Barclays proceedings, and at page 464 you have the particulars of claim, and much of it sets out the background. But what's interesting is paragraph 37 on page 471. Because you can see the way they put it in their rectification action is to add in another carve out to the definition of claims. And that rather proves the point that if the parties had intended to do that, that's what they would have done. But also the point goes further than this, because my learned friend's case in his rectification action is inconsistent with his case on interpretation, which he's now putting to this court. In this court, there is no dispute about the definition of claims. That's accepted to be common ground. My learned friend is focusing on the concept of release parties and how that fits into clauses 2 and 3. On the other hand, in the Barclays rectification action, he's saying, oh no, there was a mistake in the drafting of the agreement, and the parties mistakenly missed out another exception to the definition of claims. Now, obviously, it would be absolutely hopeless as a matter of interpretation to argue that those underlined words could somehow be inserted in as a matter of interpretation. I mean, effectively, one is implying in an additional term into the agreement, because one needs to imply in an additional carve-out. But your lordships haven't been addressed on any of the authorities on implied terms and so on, and quite clearly in our submission this would not meet the test for implication of a term. But now one sees that in black and white, it does rather, in our submission, undermine the interpretation argument that's now...
So really, I suppose the rectification claim necessarily proceeds on the basis that the agreement is to be construed in a manner contrary to that which Mr. Davis now contends.
Yes, I mean, that may be a fair point in the sense he may say, well, I'm putting the rectification claim forward contingently. But nevertheless, I mean, he's putting that forward, is he not, on the basis that represents the true agreement between the parties. I mean, it's signed by, if you go to 473, Statement of Truth.
Yes, it's...
I'm not sure how one puts...
It's becoming a rather catch-22
yes, it is.
thing. So Mr. Davis can't put forward his rectification claim until he's lost on construction. But if he's lost on construction, it's too late for him to put forward his rectification claim.
Yes, I mean, I wouldn't put it in terms of sort of absolute bars, but I think when it comes to assessing the merits of the interpretation case that he puts forward, the way it's put in the rectification proceedings does rather, in my submission, lend weight to my point that if the parties had intended to carve out this particular claim, there was an obvious way in which to do so.
Yes, your point is that they don't seek to rectify by tweaking the definition of affiliate.
Exactly. Exactly that. Exactly that. And to some extent, one gets the point anyway, even in the unrectified version of the agreement, because you already have the single carve-out to claims already. So, I mean, it sort of adds, perhaps further weight to that point. Now, in our submission, the interpretation relied on by the former administrators is not only what the language actually says, but it also makes compelling commercial sense. From the perspective of Barclays, it would obviously wish to obtain as full, final and complete a release as possible. We're under confidentiality obligations in relation to the settlement sum, but I think your lordships have been provided with that information, so your lordships know that part of the context as well, which has been redacted from the agreement. And in our submission, understandably, Barclays would want to draw a line under the matter, and it would wish to release all claims which the companies could bring against any other party, including the company's own related parties, in order to avoid any possibility of a ricochet claim. And indeed, if those claims weren't ruled out in some way or other, then it would undermine the commercial utility of the settlement agreement, since Barclays would then be at risk of having some kind of ricochet claim from another party whom the companies then sued. And your lordships know that the prospect of such claims is not fanciful, because the evidence is, I don't think we need to turn it up, but this is the administrator's evidence before the judge, that if the proceedings continued, the administrators would expect to bring a contribution claim against Barclays. Now, the only answer to this point which the claimants, the appellants, have been able to come up with is at paragraph 42 of their skeleton argument. And this is the argument my learned friend was addressing the court on this morning. And the argument is that it was unnecessary for the settlement agreement to release claims by the companies against their own affiliates, since any claim by an affiliate against Barclays is also the subject of the covenant not to sue in the second sentence of clause 3.2. So if we go back, it's probably easiest to pick this up in the settlement agreement, but if we go back to the settlement agreement, clause 3.2, and he refers to the second sentence of 3.2 And effectively the argument is that under that provision, the Rhino companies have agreed to take all steps necessary to ensure that none of their affiliates, which we'll come to in a moment, but we obviously say includes the administrators, brings any proceedings or asserts a claim against any released party. And then, in effect, derivative on clause 3.2, there's then the indemnity provision for breach, which one has in clause 3.4. Now, the first problem with that argument in our submission is that it obviously depends on reading affiliates as including the former administrators, which isn't my learned friend's case. So his answer only works if you read affiliates as including former administrators, which is contrary to what he is submitting to your lordship. But even leaving that aside, in our submission, this mechanism isn't a complete answer to ricochet claims. And the reason it's not a complete answer is it depends on the party having control of its affiliate. Now, the definition of affiliate obviously includes current employees, directors, and so on and so forth. And in relation to those people, there wouldn't be an issue because one can see that the Rhino companies probably have control over their current directors, officers, employees, so on and so forth. Even in relation to shareholders, they probably don't have control over their current shareholders. But when it gets to former directors, officers, employees, shareholders, and agents, the Rhino companies wouldn't have any control at all. And if a party doesn't have control over its affiliate, then in practice, it's not going to be sure of being in a position to ensure that a claim is not brought by that affiliate against Barclays. And you can test the position, in fact, by reference to the facts of the present case. Because let's assume that Clyde Co and the former administrators do bring contribution claims against Barclays. The appellants are not going to be in a position to stop the former administrators or Clyde Co.
Well, they are.
Well, subject to the discontinuance point, but
yes.
I mean, they're not actually, short of discontinuing the proceedings, going to be actually able to stop the issue of the Part 20 claim. They don't have any control over the former administrators or Clyde Co to prevent them from taking that step. Now, the only way out of that, as your lordship put it earlier, is to say, well, they'd have to discontinue at that point. And it may be that is the correct interpretation of clause 3.2. Although I think my learned friend takes issue with it. So that's, I don't think, necessarily accepted, at least on his side. But in any event, that is a somewhat unsatisfactory situation, I submit, so far as Barclays is concerned, because that posits that it's not going to be able to get rid of the claim without going through the steps of having the claim issued against, say, the former administrators. The former administrators then actually suing Barclays, and Barclays then potentially having to sue the Rhino companies to compel them to discontinue their claim against the former administrators. And that is probably time-consuming, expensive, and the rather roundabout way of achieving the result. The much more straightforward way of achieving the desired result is simply to release all claims relating to the subject matter of the agreement, including claims by a party against its own affiliates, so there simply isn't then any springboard for bringing a ricochet claim against Barclays at all. The other point we'd make about that is that although there's an indemnity in clause 3.4, the indemnity is obviously only as good as the credit of the provider of the indemnity. And we know, obviously, that these companies have already been in administration and subject to a CVA once. In my submission, Barclays probably wouldn't place a lot of store on being able to be indemnified by these companies. At least it's unlikely to have been regarded as a complete answer to the point. So, in our submission, my little friend's answer to say, well, actually, you don't need to construe the release provisions in the way we're suggesting in order to achieve the commercial result doesn't hold water, because the mechanic he's pointed to is unlikely to provide a complete and clear answer.
Can we just think around it from a minute? Or can I just sort of talk around it?
Of course.
So supposing Barclays wanted to be protected from the possibility of contribution claims from, say, your clients.
Yeah.
As you say, 3.2 would only work if its affiliates were construed to include the joint administrators.
Yes.
Supposing that were the case, so that in 3.2, in the second sentence, you construed affiliates to include the joint administrators, well, plainly the definitional point would fall away.
Yes.
Because affiliates would necessarily have to be construed as including joint administrators. But could the two camps argument still work?
Theoretically, yes. I don't think it necessarily strikes out the two camps argument in the way it does the definitional argument. So it's not a knockout blow in that respect, if I can put it that way. But you come back to then the 2 points, which is why does that compel you to reach a conclusion other than that which the natural language of the agreement leads you to? And the two answers to that are, firstly, even if you read it that way, this isn't a particularly secure mechanic from Barclays' perspective. And in particular, the point I just made to your lordship, in order for Barclays to get the benefit of this, it would potentially have to let itself get into a position where the Rhino companies actually sued the former administrators, the former administrators then sued Barclays, and Barclays then had to sue the Rhino companies to then discontinue. But secondly, this is just an argument based on redundancy. Now, my little friend's point, as I understand it, is that because of 3.2 second sentence, it's unnecessary for the settlement agreement to release claims by a party against his own affiliate. It's effectively saying, well, because you've got that mechanic, you don't need the release which takes effect in the way we suggest. But in our submission, the logic of that simply doesn't follow. And it's more likely that the draftsman was simply intending to put in as much different protection as possible and to make the effect of the settlement agreement in preventing future claims as wide as possible. And there's a memorable phrase from Lord Hoffman in one of the authorities, which is referred to in Lewison, where he says that in these sorts of agreements, the technique of the draftsman is often to obliterate the conceptual target. And that's vivid language, but obviously what he means by that is the draftsman is throwing various different techniques at seeking to achieve the end result. And as your lordships know, as a matter of contractual interpretation, arguments based on redundancy are, it's said, seldom secure. And I'm not sure I need to take your lordships through the cases. We've put in the bundle the relevant extracts from Sir Kim Lewison's book at paragraph 7.24 to 7.36. And he essentially goes through the very large number of cases, all of which essentially make exactly that point. So an argument on redundancy doesn't get one very far in any event, and certainly it doesn't come close, we'd suggest, to shifting away from the natural meaning of the language. Now, just whilst we're on that point, my little friend mentioned in his submissions that this type of way of dealing with ricochet claims, namely releasing claims by a party against its own related parties, is unusual. My lords, there is no evidence of that. Your lordships have no evidence as to how, under modern conditions, draftsmen in city law firms do go about dealing with ricochet claims. That in my submission, is simply an assertion that isn't supported by any evidence at all.
I think what he said was that they looked in the cases in the books to find examples and not found any.
Well,
that's a legitimate.
Yes, I mean, I think so far as reported cases are concerned, I think that's probably a fair point. I mean, I don't think it's fair to say there's many cases, there's many examples either way, actually. I think what one gets is simply that reference in paragraph 9.5 of Heaton, where Lord Bingham gives an example of the way in which they might be dealt with. That's, as we'll come to, a slightly different context, because he's dealing there not so much with the construction of a settlement agreement, but with the effect of payment of a settlement sum to one joint and several creditor.
My note is that what Mr. Davis said, there was no precedent in any judgment for this, and they hadn't found any indication that it's a recognised means of achieving the objective. So I didn't take him to be giving evidence.
No, well, if he's not giving evidence, if it's just a statement as to the reported cases, then I think that's probably fair comment. But I think what I would comment in response is to say, well, actually, there's not many cases dealing with that particular subject one way or the other, actually.
And just so I'm clear, trying to be clear about what we're dealing with here. The question is it whether, in terms of reported cases or otherwise, you would normally expect a draftsman to have something equivalent to the second sentence of 3.2 and 3.4,
yeah,
and leave out the first sentence.
Yes.
Yeah.
And I suppose, I mean, I would perhaps add the further point. I'm not sure when one's looking at the mechanics of a particular agreement that reported cases may necessarily help hugely, in the sense that you'd have to look at each agreement. Now, just on this, there's another topic dealt with in my little friend's skeleton argument, which he didn't deal with orally, but I will just deal with it quickly. For completeness, it's in paragraphs 37 to 40 of his skeleton argument, which is page 57.
He did touch on this. I think.
Yes.
He may not have taken us to these passages, but he did say that it would be ridiculous to restrain Barclays from doing those things.
Yes. So well, let me deal with it, because he has given examples of certain claims and matters, and it said, well, it can't have been the intention to release those claims. Now, if we just look at paragraph 38, where there's 4 examples given A to B. First point is that there is, in our submission at lowest, clearly some doubt as to whether the matters mentioned would fall within the definition of claims in the settlement agreement at all. Certainly so far as D is concerned, that I don't think is a claim, because that's talking about defending a claim rather than making an outgoing claim. It's also not far from clear that, to take B, that an overpayment of fees to Clifford Chance falls within the subject matter of the definition of claims. And so far as an expert's concerned, well, there's going to be a question as to whether the expert is in fact an employee or an agent, as to be a released party. So we respectfully suggest that some of these examples might be said to be a little contrived potentially. But generally, the settlement agreement was in our submission likely to have been intended to draw a final line on any claims relating to the claims which had been asserted in the Barclays action. And there's no reason to think that the examples given by the appellants in paragraph 38 were of any significance at all to Barclays, or even if they were, that such significance was not entirely outweighed by the desirability of obtaining a full and final settlement, an entirely clean break from the claims brought by the Rhino companies. So put another way, it's far from uncommercial to reach a conclusion on the part of Barclays that it was willing to pay the price of giving up whatever rights it may or may not have had in relation to these types of matters as part of the price for simply getting a complete withdrawal and a complete release of anything relating to the claims that have been brought against it in the Rhino action.
Particularly if one hypothesises, and I emphasise the word hypothesises, part of Barclays' objective might have been to avoid any publicity.
Yes. Yes, I mean, that's a fair point. And I think, I mean, your Lordship will have picked it up, but there obviously is an elaborate confidentiality provision in the settlement agreement. Yes, which I mean, it goes to the lengths of setting out the terms of the statement which the parties are obliged to issue if they do make a statement approached by a media outlet. So, I mean, that's, I respectfully submit that is a fair point. But ultimately, there's nothing. It's certainly not. One can't say, well, actually, that is so uncommercial that possibly can't have been the intention, and one is therefore driven away from the natural and ordinary meaning of the language. Now, the other point, just on the two camps argument, is the section of my learned friend's skeleton argument at paragraphs 18 to 32. So to go back to divider 4 at page 51. Your Lordships might recall from the skeleton that the technique was effectively to begin the submissions by spending quite a lot of time, I think it's about 6 pages of the skeleton, pointing to drafting infelicities in what are said to be drafting infelicities in the settlement agreement. Now, some of them, I think, clauses 3.1 and 3.2 potentially go beyond that, and I've already dealt with those points and explained our submissions in relation to clauses 3.1 and 3.2. So as far as the other points are concerned, we respectfully suggest that these are weak points in terms of criticisms of the drafting. So even as criticisms of the draftsman, they are weak points. But they also don't go anywhere in any event in our submission. Ultimately, it doesn't get the appellants very far to show simply that there are some infelicities of drafting in the settlement agreement. It would be rare, probably, to find an agreement without some imperfection. But that itself doesn't get them very far at all, because they still need to establish that their own interpretation of the agreement and the relevant clauses and definitions is correct. Now, in any event, the points on alleged drafting errors are, in our submission on analysis, very weak indeed. We've dealt with them in paragraph 23 of our skeleton argument, behind divider 6, page 97. The first was a point made in relation to clause 2.1. I don't, I'll be corrected if I'm wrong, I don't believe my friend pursued that orally.
I understood him to do so.
Well,
on the basis, really, pushing the skeleton.
Well,
I think I then diverted him to clause 3.1.
I see.
But
well,
I don't think he was retracting what he said about
well, maybe I'm being unfair, in which case I apologise. But the point of substance is that there's nothing in the criticism, because clause 2.1 works perfectly well when you read it literally. It's clear each party releases all claims against any other party or against any other released party. There is in our submission no difficulty in the wording of clause 2.1. And then if we go back to the skeleton, our skeleton, paragraph 23b, there's then, in effect, a second point, which is to say that if you apply the literal definitions of surplusage within clauses 3.1 and 3.2, because a party cannot release itself from claims or a party cannot sue itself. And I've already dealt with that in relation to clause 3.1. In our submission, there isn't any difficulty in 3.1. So far as 3.2 is concerned, as I submitted earlier, as a counsel of perfection, you could say, well, the draftsman has over-compressed the reference to any released party in the last part of the first line. It's a point about surplusage, essentially. It carries little weight, but in any sense, in any case, it's easily remedied as a matter of construction, simply on the basis that clause 3.2 is read to conform with clause 2.1. And then the other examples, as we say in subparagraph C and D, are essentially the same point, just in relation to different clauses. My friend did refer to both these clauses in his submissions. The first is clause 7.2, and the second is clause 9.5. Perhaps if we just turn those up, because it's probably easiest. Your Lordships, to have the clauses in front of you. And clause 7.2 is page 450. This is obviously part of the representations and warranties. Each party represents and warrants that it's conducted such inquiries and taken such advice that it considers as necessary in order to enter into this agreement, and that in doing so it has not relied on anything said or done or not said or not done by or on behalf of any released party. And I think the argument is, again, essentially the same point. Well, a party wouldn't normally represent a warranty that it's not relying on anything said or done by itself. Now, in our submission, that falls into the category really of a counsel of perfection. I mean, it doesn't affect the sense of the clause in any way. If one was wanting to be a perfectionist about it, one might again criticise the draftsman for not having put the more extended formulation, which you see in clause 2.1, rather than using the more compressed phrase, any released party. But it goes no further than that in our submission. And we query whether actually there is any defect at all here. He's just making clear that the parties aren't relying on anything that's been said and done by anyone, except to the extent it's expressly set out in the agreement. It's effectively a counterpart to the entire agreement clause, saying everything represented or warranted which has been relied on is set out in the agreement itself. Certainly there's no difficulty about that in our submission. And then the other one is clause 9.5. And this is another warranty, this time page 451 of the bundle. So each party warrants to the other parties, so no difficulty with that. But as at the date of this agreement, no proceedings other than the action arising out of or connected with any claims have been commenced, are pending, or to the best of its knowledge are contemplated against any of the released parties. Now, our main point in response to that is to say, well, there's no difficulty with that, read literally. Because each party is warranting that there are no claims which have been commenced, pending, or to the best of its knowledge, contemplated against any of the released parties. And that could include the party itself, actually. It could warrant that it's not aware of any claim that's been threatened against itself. So we don't accept in relation to clause 9.5 action as any drafting issue at all. Looked at overall, in our submission, the agreement is actually clear and well drafted. If we go back...
Yes, but can I ask you a question about that? Because I'm not sure you're quite meeting the gravamen of Mr. Davies' point, certainly as articulated orally this morning. And what you're currently focusing on is an argument that applies to all written documents, which is, to use the language that Mr. Davies adopted this morning, comes from Wood and Capita of textualism versus context.
Yes.
And the argument is, well, if you've got an agreement which on its face has been carefully drafted by skilled professionals, and here we've got two well-known firm solicitors on the respective sides. So the presumption in those circumstances is that you can rely on the text.
Yes.
So you give more weight to textualism as against contextualism. By contrast, if it's an agreement made between two businessmen of little education and certainly no legal training, then you would give less weight to the text and more weight to the context. That's the type of argument one has with any written agreement.
Yes.
Whereas what Mr. Davies was focusing on this morning was much more the particular specific problem one has with settlement agreements, which is that one knows from history that there is a tendency when drafting settlement agreements to include broad, all-encompassing language, when in reality that can't possibly have been the real intention of the parties.
Yes.
And so I think he was really focusing his argument on the latter aspect of it. I mean, it wasn't even by any means abandoning the first aspect,
Yes.
but I think he was putting more focus on that second aspect. And on that aspect of the matter, does it help you to say, well, actually, there's only slight infelicities, because that doesn't really meet the point, which is to say, yes, they've used broad language, but can they really have intended for it to be as all-encompassing as it appears to be if interpreted literally?
Yes, no, I understand the point your Lordship's making, and I think these particular points, I wouldn't put them forward as really being a positive point to me. I was really seeking to answer his point, certainly the way it's put in the skeleton argument, which is the way he sought to approach it, I think, is to point to various defects in the agreement, and then to use that effectively as the platform to make the submission, well, you can't adopt an over-textual approach to this agreement because, look, there's bits of the agreement where there are errors. And he says that sort of, I think he sort of relies on to open the door to a slightly different approach. And my submission is simply to say, well, no, that doesn't work here, because what you're alleging to be errors aren't in fact errors at all. Or if they are, they're trifling, actually. And what they don't do is allow or justify one in departing from what would ordinarily be quite a close reliance on the language that's being used. So I'm perhaps, it's more of a sort of point put forward by me as riposte to the way the argument was put, certainly how it's framed in the skeleton argument rather than a positive point. Now, just to complete that point, to make sure we've finished it off, that there was a final example which we refer to in subparagraph E on paragraph 23 of our skeleton argument, page A98. And your lordships may recall, my little friend referred to this this morning. It's the fact that clause 6 of the settlement agreement refers to legal advisors, and it said that that was unnecessary because legal advisors are also agents. And we respectfully submit, again, there's nothing in that as a criticism of the agreement. It may not necessarily be the case that a legal advisor is always an agent. But even if you could say that, then we would suggest this is, again, just an example of belts and braces drafting. It's something that's hardly surprising, particularly in the settlement agreement. It doesn't go anywhere. So ultimately, where you get to on the two camps argument is in our submission, it's not supported by the contractual language. The contractual language is clear. One isn't compelled to depart from the ordinary natural meaning for commercial reasons. In fact, the ordinary and natural meaning of the language is supported by commercial considerations. And ultimately, we respectfully submit a straightforward construction exercise. One simply applies the language as the parties have stated. Added to that, the point that if the parties had wanted to carve out these claims, they could very readily and easily have done so in the manner in which they did carve out the one claim they mentioned. So that, in our submission, is the two camps argument, and obviously we submit that the judge was correct to dismiss that argument. The second argument is the employee argument, and this is the argument that the former administrators don't fall within the defined term employee contained in the settlement agreement, and because they don't fall within that, they're not within the category of released persons. Now, we say that they do because they are both former agents and former officers of REPL and AIL, two of the parties to the settlement agreement, and either is sufficient. In fact, they're both, but either is sufficient. Now, so far as agency is concerned, it's straightforward in that paragraph 69 of Schedule B1 provides expressly that in exercising his functions, an administrator acts as agent of the company. Now, we've got that behind divider 8 of the First Authorities bundle in the extract from Seeley and Millman. It's at page 128 of the bundle. And it's very clear, in exercising his functions under this schedule, the administrator of a company acts as its agent. Now, it's true that not everything an administrator does is carried out in his agency capacity. But everything he does in discharging his functions as administrator under Schedule B1 is. And in our submission, in order for someone to fall within the definition of agent, or to be an agent, to fall within the definition of employee in the settlement agreement, it's not necessary for everything they do to be carried out in that capacity. It's just they have to be an agent of the company in relation to some of the functions which they carry out. And there's no doubt at all that an administrator is an agent of the company for the purposes of discharging his functions as administrator. Now, just on that, it's perhaps also worth noting, in the pleadings bundle, you have the points of claim, particulars of claim rather, in the action against the former administrators. And if your lordship turn to page 20, so paragraph 26.
Sorry, can you Give me the page number again.
Page 217.
Thank you.
It's just to make the point that the appellants actually rely on the agency function of the administrators, and they rely on it in paragraph 26 for the purposes of saying that the instructions that were given to Clyde Co were given by the administrators as agents of the companies. And if you go to paragraph 25 of the defence at page 258, that is admitted. And contrary to the appellant's submission, it makes no difference, we suggest, that the agency is statutory in origin, or that administrators are often appointed by the court or by creditors rather than the company itself. In any case, they are still agents. So that's the agency argument. The alternative argument is that they are also former officers of the companies. Now, there are a number of authorities which support the proposition that administrators are officers of the company over which they're appointed. And we cited those to the judge. And they're referred to at paragraphs 86 to 88 of the judgment. It might be helpful just to turn that up, because I'm not going to take you to those cases. There's one additional case that's been handed down since, which I was going to take you to. But if we begin at paragraph 86 to 88, which is in the core bundle behind divider 12, and it begins at 86, and then the first case referred to is a decision of Re-X Company, which decided whether a voluntary liquidator was an officer, and it was held that he was. And then of more direct relevance for our purpose is the decision referred to in paragraph 88 of the judgment, which is a decision of Mr. Justice Harman in a case called Re-Home Treat Limited. And the issue which arose in that case was whether administrators were officers of the company for the purposes of taking advantage of the exculpatory provision in the Companies Act, which at that time was section 727 of the Companies Act 1985. It's now section 1157 of the 2006 Act. And you can see that Mr. Justice Harman reached the conclusion that they were. And he gives his reasoning in the quote that was set out by the judge. And Mr. Brisby submits to me that an administrator appointed by the court to conduct the business of the company with a view to a better realisation of its assets, or indeed, as in this case, with a view to the survival of the undertaking or part thereof, the going concern must surely, even more than a liquidator, be a person properly within the context, an officer of the company. Mr. Brisby puts it that on the words of the English language, an administrator plainly holds an office. That's certainly correct. He's an officer of the court. That is undoubtedly correct. He's also, by conducting the business of the company, it seems to me, an officer of the company. He's appointed under Section 82 of the Insolvency Act by an order directing the affairs, business, and property of the company should be managed by the administrator. Seems to me quite clear that the word officer, which merely means someone who holds an office, and an office in relation to the company can apply to an administrator. That's so, although he's also an officer of the court, there being in that context no conflict of duty between his duty as officer of the company and his duty as officer of the court. In both capacities, his duties are to manage the business and property of the company for the better effecting of the purpose for which the court made the order in the interest of creditors, and it may be eventually of the contributors of the company. Now, the decision in Home Treat was subsequently followed by my Lord, Lord Justice Newey, sitting at first instance in a case called Repowertrain, which is in Authorities Bundle 2, behind Divider 35. And this was a case, again, concerning liquidators, and it gave rise to essentially the same question, which had arisen in relation to administrators in the Home Treat case, namely whether the liquidators could rely on what was now Section 1157 of the Companies Act 2006 to exculpate them from any claim for negligence, breach of duty, or breach of trust, and so on. And if you go to paragraph 11, you can see from the second part of that paragraph that my Lord relied on Home Treat in particular, and applied that reasoning in that case to the position of a liquidator. And the most helpful authority is perhaps Home Treat, where Mr. Justice Harmer was concerned with the position of an administrator and expressed the view that it was quite clear that the word officer, which merely means somebody who holds an office, and an office in relation to the company can apply to an administrator. And then that was applied to the position of a liquidator. And I should say that is an ex parte judgment, so it's on the benefit of submissions made on behalf of the liquidators. Now, there is also, since the decision of the judge, one other case that's been handed down by this court, which directly bears on the question and comes to the same conclusion. But I will just show you that, if I may. It's in Authorities Bundle behind Divider 43. Authorities Bundle 3 behind Divider 43. I'm sorry, I said it was of this court. In fact, it's of the Divisional Court. Lady Justice Andrews, Mr. Justice Linden. Now, this was a case where, in fact, criminal proceedings were brought against a director, an administrator of a company in the Sports Direct group for failing to give proper notice of redundancies as required by the employment legislation. So it's a salutary lesson, as it happens, for administrators. That's what it was concerned with. But what matters for our purposes is the point that was the argument that's recorded as having been made in paragraph 3 of the judgment, where Mr. Palmer, who was the administrator, contended that as administrator of USC, which was the company, he cannot properly be made the subject of a prosecution for an offence under section 194 subsection 3 of the Trade Union and Labour Relations Consolidation Act, because an administrator is not a director, manager, secretary, or other similar officer of the company. This argument was referred to before as the officer argument. Now, there's a lot of background in the judgment which deals with other points that were made. The officer issue is dealt with paragraph 96 onwards, page 939 of the judgment. And there's a quite lengthy discussion which goes through all of the authorities. It begins at paragraph 99 and over on the next page by setting out the statutory provisions relating to the Office of Administrator. And then if you go to 102, halfway down that paragraph, you can see the submission that was made was that an administrator is not a manager or similar officer of the company, while he does have wide powers of management of the whole of the company's business. He's not an officer of the company, nor is he in a position similar to those of the identified officers, i.e. a director, manager, or company secretary, because although he's managing the company's affairs and taking all the same types of decisions would have taken prior to the company going into administration, and he's an agent for the company, that was common ground it seems, he's not subject to the same duties. So that was the argument that was being put. Now, in terms of the authorities, paragraph 106, the court referred to a decision in a case called Reed Johnson and Co Builders, which concerned the question of whether an administrative receiver was a manager or officer of the company. And in that case, it was held by the Court of Appeal that an administrative receiver was not an officer or manager. And that's essentially because his powers under the debenture, under which he's appointed, are to manage the company's property and not the company per se. And you get that, it's really paragraph 107 and then paragraph 109. The distinction there is the powers of the administrative receiver are derived from the terms of the debenture, and essentially under the debenture, what the administrative receiver has to do is collect in and manage the company's property rather than the company itself. And then 114...
Well, that's the vice of everything, but then also quite helpful is the underlying bits from Lord Justice Parker's judgment of 111.
Yes, indeed. Quite. Yes, I mean it's a very helpful section generally, and I try and do it justice in terms of in summarising it. But it does very helpfully provide a survey of all of the case law. So that case effectively answered the question in the negative so far as an administrative receiver is concerned. But then you get to 114, where the court notes that Mr. Ozin pointed to a different line of authority in which an administrator or liquidator has been treated as an officer of the company. And this is in effect the line of authority we relied on before the judge. So the first one is re X company, then re home treat. And they set out at 116, the quote from Mr. Justice Harman, which we've already looked at. 117, my Lord Justice Newey and re Powertrain. And then 118, they say the decision of the Court of Appeal in Reed Johnson was not cited to the court in home treat or Powertrain, but it is easily distinguishable. The section of the Companies Act under consideration in Reed Johnson that expressly applied to a liquidator, and a receiver has far more limited functions and responsibilities than either a liquidator or an administrator. And then they say 119, it wasn't suggested, can't sensibly suggest that the question whether an administrator is an officer of the company turns on whether he was appointed by the court or out of court, or if he was appointed out of court, whether he was appointed by the company itself, its director or qualifying creditor. And then where the court ultimately gets to is having sort of considered what the consequences would be if an administrator wasn't an officer. The conclusion is in paragraph 129. Part of this is obviously based on, I accept, the statutory context of the particular legislation they're looking at. But they get to the conclusion in 129, about a third of the way through the paragraph. Mr. Justice Harman's analysis of the role of the administrator in home treat and his reasons for concluding that an administrator is an officer of the company in the context of relevant provisions of the Companies Act, with which he was concerned, seeming to us to apply with equal force in the context of sections 193 and 194. The administrator is both an officer of the court and an officer of the company. Harman and J explained the two roles are not mutually inconsistent. an administrator manages the company itself and its business by virtue of the office and has a specific power to dismiss the company's employees. He's not in an analogous position to an administrative receiver. So the judge was, in our submission, right, not only for the reasons he gave, but also for those reasons subsequently supplied by the Court of Appeal, the Divisional Court in that Northern Derbyshire Magistrates case. Now, my learned friend, just for completeness on this point, there's a sequence of points made in paragraphs 50 to 57 of my learned friend's skeleton argument, core bundle 4, page 63. Now, the first point in paragraph 50 is that it's said that Barclays and the settlement companies knew and understood that all claims against the joint administrators had already been identified and reserved. Now, I mean, one might say at the outset, why is this point particularly relevant to the employee argument? I mean, it seems, as a point, if it goes anywhere, it's possibly relevant to the two camps argument, but leave that as it is. In our submission, it's not a good point, and in fact, it's a point my Lord Justice Arnold observed earlier goes against my learned friend. First, the fact that the particulars of claim in the Barclays action reserved the right to bring a claim against the former administrators has no bearing itself, or provides no support itself, for the conclusion that the settlement agreement didn't intend to release such claim. In fact, it goes in the opposite direction because it shows that the parties were aware of the potential existence of such claims and potential for proceedings, but that they didn't carve them out of the definition of claims in the way they did that other claim which had been identified. But it also doesn't bear on the question of whether an administrator is an officer or an agent in our submission. Paragraph 51, the argument is that the claims are made against the administrators personally and not as agents. But that doesn't help either, because the release isn't limited to claims made against the former agents qua agents. Rather, how the settlement agreement works is you have to be a former or existing agent to form within the scope of the released parties. But once you're within the scope of the released parties, then any claim made against you, which falls within the definition of claim, i.e. broadly relates to the subject matter of the action against Barclays, is released. It doesn't have to be a claim made against you qua agent.
I wonder slightly whether it works or would work anyway. It's a breach of fiduciary duty claim, isn't it? That's made against you in this respect. That the reason you shouldn't have taken the appointment or should have stepped down is breach of fiduciary duty. Or is that wrong? I haven't studied
it's breach of duty. I was just wondering whether it's fiduciary duty or not. I suspect your lordship's right because it's put in terms of conflict of interest. So broadly, that's right. Yes.
I mean, if it were right, then I suppose you can be a fiduciary without being an agent or an officer, but it sort of has the flavour of agent or officer.
It does. It does. I mean, you're certainly right. It's dependent on you owing some sort of duty of loyalty towards the company over which you're appointed, because otherwise you don't get into the subject matter. Paragraph 52. This is the argument that the administrators are not named specifically within the definition of employee, which is true. But in our submission, it doesn't assist. The definition of employee is clearly very general. We'd suggest deliberately so. And it was therefore unnecessary to name further specific persons, such as particular categories, of insolvency office holder.
I mean, just thinking about that for a moment. It names directors,
It does.
and then it says officers. Officers must be intended to add something to directors.
Yes.
So one must be contemplating officers who are not directors.
Yes.
I don't know, secretaries. That's a pretty narrow class. Why
Yes.
didn't it just say secretaries?
Well, that would have to be the argument on my learned friend's case. I mean, our case is obviously it was put very, very broadly, and essentially intended to capture anyone associated with the companies. So directors, officers, employees, shareholders and agents. I mean, looking at the phrase as a whole, it's extremely broad. And in our submission, it's unnecessary for the parties to, within that very broad group of categories, to then have identified particular subcategories, as it were. Paragraph 53 is the point about the point my learned friend made in his oral submissions this morning, that you can't get anything out of the fact that there wasn't a reservation of right to sue the former administrators, which is a point that the judge did in our submission correctly note. It's not a point that is essential to the conclusion, but it is a reasonable point to make, that if the parties had intended to preserve claims against the former administrators, they could have made this clear in the definition of claims. In our submission, Heaton is really concerned with a different point, because it's not concerned with the interpretation of release clauses within a settlement agreement. I think I'm probably repeating the point my Lord Justice Arnold put to my learned friend this morning, but if we go to Heaton, in Authorities Bundle 2, behind divider 22, and we go to paragraph 9 on page 321. In our submission, it's very important when looking at paragraph 9 to begin with the opening words of the paragraph. Because in the opening words of paragraph 9, Lord Bingham identifies the question which he's dealing with, which is simply the assessment of whether a sum accepted under a compromise agreement should be taken to fix the full measure of loss. So it's simply a question essentially based on what are the consequences of acceptance of a sum of money. I mean, he's not dealing here with interpretation of third-party release clauses entered into as part of a settlement agreement. And the point he makes in subparagraph 4 of paragraph 9 is directed at that question. While an express reservation by A of his right to sue C will fortify the inference that A is not treating the sum recovered from B as representing the full measure of his loss, the absence of such a reservation is of less and perhaps no significance, since there's no need for A to reserve a right to do that which A is in the ordinary fully entitled to do without any such reservation. So that's the consequence of simply accepting the sum of money. Now, in our respectful submission, that clearly has no application to the construction of the release clauses in the present case, and particularly when one is dealing with the definitions of claims in the present case, which already, as we've seen, carves out one claim. I mean, that dictum of Lord Bingham doesn't, in our submission, bite in relation to the construction of a settlement agreement with release clauses where you have a definition of claims and where some claims have already been carved out. So we respectfully say it doesn't answer the point. It answers the question where you're just talking about what are the consequences of receipt of the sum of money. It doesn't go beyond that. And the same applies. I wasn't going to go to them separately, but it's exactly the same point in Gladman in our submission and in McGill. If we just go back to the skeleton and just wrap up the points on the employee argument, then paragraphs 54 through to 56 essentially make the point that the administrators had releases under other mechanisms. Firstly, because there's a release followed upon their discharge of administrators under the terms of Schedule B1 of the Insolvency Act. And then secondly, under the terms of the CVA that was entered into. Now, in our submission, those points are easily answered. So far as the release under Schedule B1 is concerned, even if the parties had that in contemplation, the release under Schedule B1 isn't an absolute release. Because under paragraph 98, sub 4b, the court has the power to permit a claim to be brought in any event. So although it's described in terms of a discharge and release from liability, in practice it's far from that. And one knows that the court will apply a fairly low threshold in permitting claims to be brought. They just need to establish a basic level of merit. There isn't any presumption that a claim shouldn't be brought as a matter of policy. All the release does is effectively apply a filtering mechanism so that permission won't be given for something that's absolutely hopeless, but if it gets above that, it will be allowed to proceed. So it's not actually a full release anyway. The CVA release clause, likewise, and indeed the claimants have challenged the efficacy of the CVA release clause. And we know from the proceedings before His Honour Judge Barker that they were successful in doing that. But also, going back to my other point, I mean, these are essentially an argument based on redundancy. And the fact that there are these other mechanisms out there of greater or lesser efficacy, which the parties may or may not have had in mind, doesn't mean that when they're constructing the settlement agreement, they wouldn't have intended to have a very clear and effective release of all the claims by a party against its affiliate that might have supported any ricochet claims. And then paragraph 57. So far as this is concerned, we ultimately say, well, that's assertion, because it takes as its premise that there are these two camps of insiders and outsiders. So it effectively just takes one back to the two camps argument. It takes as its premise that there are these two camps, and we dispute that. So, my lords, that's interpretation. I was going to then turn to grounds 2 and 3 of the appeal, which concern the evidence of Mr. Schofield. And obviously, your lordships know from my learned friend's submissions that the appellants seek to rely on certain evidence given by Mr. Schofield about what he says was said during the discussions which led to the mediation, and then the mediation itself, which led to entry into the settlement agreement. Now, by way of overview, in our respectful submission, my learned friend is caught in a difficulty on this part of the case. If one takes the parts of the evidence of Mr. Schofield, there's, in our submission, 2 logical possibilities. The first is that it is evidence of an objective fact, in which case it might be admissible, but it doesn't assist him. And if one can test that, because if one identifies what the objective facts are, they're firstly that the parties, that Mr. Schofield was making complaints and threatening claims against the administrators. And then secondly, and specifically, that there was a reservation of right to bring such claims contained in the particulars of claim in the Barclays action.
Well, as I understand it, I'd like to be clear, you don't dispute that either of those things were both facts and were facts known to the contracting parties. Indeed, as I understand it, you positively rely upon them.
We do. So this is exactly. So far as that's concerned, and in our submission, that's the limit of the objective fact that can be extracted from Mr. Schofield's evidence. Now, so far as that is concerned, we don't dispute it. We accept that is admissible for what it's worth. But it doesn't help my learned friend. In fact, it positively makes his life more difficult, because all those objective facts lead one to is the conclusion that Barclays was well aware that there were these potential claims floating out there. And one assumes, behaving rationally, that Barclays would have wanted to assure that those claims couldn't come back and bite it somehow. And that's why, in my submission, there was a quite telling exchange this morning between my learned friend and your lordships, when that point was put to him, my learned friend. And ultimately, what he had to do was to have recourse immediately to what is quite clearly evidence of subjective intent and negotiation. Because he said, oh, well, that doesn't matter, because actually Barclays did not intend to release the joint administrators and left it to Mr. Schofield to pursue such claims. The only way my learned friend can deal with those points is by having resort to what he says on the basis of Mr. Schofield's evidence was the subjective intent and or the agreement and or the understanding with Barclays. Now, that category of evidence, which in our submission is actually the bulk of what Mr. Schofield says, is quite plainly inadmissible as evidence of subjective intent and of negotiation. And I don't think there's any real dispute that evidence of pre-contractual negotiation and of subjective intent is not admissible to interpret a written agreement. It's the third principle stated in Investors' Compensation Scheme. We've set out the relevant extract from Lewison, paragraph 3.43. There's also the point my learned friend, Lord Justice Arnold made, which I'm afraid we didn't pick up on, which is clause 5.1 of the settlement agreement, which explicitly excludes evidence of negotiation except for the purpose of enforcement, which is clearly what isn't happening here. So, as I say, this part of the case ultimately causes my learned friend difficulty because the objective fact is unhelpful to him. He has to have recourse to the subjective intent and the evidence of understanding stroke agreement. That is out. Now, I'll come in a moment, because this is really the foreground to the weight of Mr. Schofield's evidence in any event, given what we now know Barclays are saying, but that's a slightly later point. If we just pick up again my learned friend's skeleton and go to divider 4, paragraph 59. And just use this as the basis for picking up the points that are made. Paragraph 59 is a point which I do not believe to be pursued. I'll be corrected if I'm...
Well, it certainly wasn't pursued already.
No,
If it had been.
I accept that.
Thank you. I said that diffidently because normally I get it wrong for not having listened carefully enough, but I'm grateful. So that takes one to the second point, which is factual matrix. And and in our submission, in this part here, there's really two contradictory points. I mean, so far as paragraph 61 is concerned, as I say, insofar as the evidence is of objective fact, it is admissible. As I say, it's unhelpful. We do take issue with the second sentence of paragraph 61, because it's difficult to understand what the difference is between evidence which is not of negotiation or subjective intent, but of objective fact as to the existence of a common understanding and agreement. I mean, if it is of evidence as the existence of a common understanding and agreement, well, that is evidence of subjective intent, excluded by the parole evidence rule, amongst other things. And likewise, in paragraph 62, there seems to be a conflation, because we accept evidence as the factual matrix, which includes evidence of objective facts, as I explained, is admissible. But evidence of previous negotiation isn't. And in our submission, it conflates and is unhelpful to say that evidence of previous negotiation is part of the factual matrix. And when you look at when you look at investors' compensation scheme and the 5 principles set out by Lord Hoffman, it's quite clear that he regarded evidence of previous negotiation, which was his principle 3, which is inadmissible, as being distinct from evidence of the factual matrix. So we respectfully suggest that conflates 2 points. And just to pick up one point on the evidence of common understanding and agreement, which is referred to in paragraph 61. In response to that, we referred to the entire agreement clause, which is contained in clause 7.1 of the settlement agreement. My little friend came back on that in his supplemental skeleton at paragraph 458. Paragraph 9. And referred to a case called NHS Commissioning Board against Fassand. And he says the fact that the contract contains an entire agreement clause does not exclude extrinsic evidence from being admissible to aid the process of construction. Well, we accept that, but we were making a different point by reference to paragraph 61 of his skeleton argument, which is what it does exclude is reliance on some sort of collateral, common understanding or agreement, which is said to exist outside the terms of the written settlement agreement. If you go back to paragraph 61, behind divider 4, what is excluded is evidence of an existence of a common understanding and agreement which is said to exist outside the terms of the written settlement agreement. It's excluded by the parallel evidence rule. It's also excluded by the entire agreement clause. Entire agreement clause doesn't exclude evidence of factual matrix or objective fact, but that's a different point. Now, the final point made in the skeleton argument is paragraph, I think paragraph 63. And this is the point that was relied on to quite a large extent below, less so before this court. Certainly my reference to all those submissions, which is said to be the proposition that evidence of pre-contractual negotiations is admissible to identify the subject matter of a settlement agreement. And the case which is relied on for these purposes is a decision of this court in Datani against Trio Supermarkets, which was an employment case. If I can just ask your lordship to turn that up. It's in Authorities Bundle 1, behind Divider 17, page 206. And the reason for taking you to the case is that in our submission it's very important to have a look at what the facts of this case actually were and what it was actually concerned with. As I say, it was an employment case, and there had been an unfair dismissal claim brought by the shop manager, which had gone before the industrial tribunal. And it had been compromised, but not in terms of a written settlement agreement. And in fact, if you go to C209, 875F of the report, the settlement was simply recorded in a document called Decision of the Industrial Tribunal.
Sorry,
I'm sorry, it's page 875F, page C209 of the bundle.
I see, yes.
So the limit of the document recording the settlement was this document called Decision, issued by the Industrial Tribunal, and effectively all it said was, this case has been settled on the basis that the company pay Mr. Datani the sum of £5,000 at the rate of £1,000 per month. So that was it. Now, there was then a dispute as to whether the settlement also settled a claim for unpaid wages, which Mr. Datani subsequently issued proceedings for. And as part of that action, there was a dispute as to what had been settled in the earlier industrial tribunal action. And they were put before the court as part of the exercise of trying to determine the scope of the settlement, two statements from counsel who'd represented the company at the industrial tribunal claim. And you see those referred to between 876 F to G. There are included in the appeal bundle two statements by the counsel who represented the company at the hearing of the industrial tribunal claim and was involved in the settlement of it. And then one of the questions, if you go over to 877 against C, you can see that that evidence was in fact agreed. Counsel didn't intend to give evidence, and then 877E, the second statement, was also agreed. So it was not contested evidence. Now there was a question on res judicata, which I don't think matters for our purposes, but then also a question as to the scope of the earlier compromise, which Lord Justice Mummery dealt with beginning at page 880E, page 214. And he referred to Mr. Foskett's book on pages 880 and 881. And then at 882, underneath letter B, he dealt with the question of the admissibility of the statements that had been put in from counsel. He said, in this case, there's a paucity of material on the compromise. There's no agreement in writing signed by the parties recording what they had agreed, which is important. It's a distinction from our case. And then the court has three pieces of evidence. A letter guaranteeing the terms of the payment, the record of compromise stated briefly in the decision of the industrial tribunal, and thirdly, the two statements made by previous counsel. And Mr. Starley-Brass submitted that naturally now the company was now saying, well, actually, you should ignore the evidence from counsel, even though that had been put in by the company itself previously. And then at the bottom of 216, having referred again to Mr. Foskett's book, he came to the conclusion the critical evidence contained in the agreed statements of counsel falls within that ambit of admissible evidence, namely extrinsic evidence to identify the disputes which the parties by their agreement were endeavouring to resolve. And on that basis, he accepted that evidence in and relied on that to come to the conclusion, which you can effectively see at 885, just above B. And he came to the conclusion that the compromise should be limited to compromise of the unfair dismissal claim. Now, in our submission, that case doesn't help, so far as we're concerned, for the main reason that there was no written agreement. It's very different to the present case, where there is a full and carefully drafted settlement agreement. Amongst other things, because we have a written agreement, the parole evidence rule applies. And, of course, the rules as to construction apply. My learned friend accepted correctly that there's no different rules of construction for a written settlement agreement as compared with any other type of written contract. And Datani, which was essentially concerned with the court trying to reconstruct what had been agreed in the absence of any written agreement, is, we would respectfully suggest, a rather different situation. One can understand why, when the court didn't have a written agreement, that evidence was regarded as admissible and relevant to work out what had actually been settled. It's obviously far removed from the present case, and ultimately we suggest doesn't assist. Now, my Lord, I've actually made reasonable progress on time, so I will just finish off, if I can, just with a few points on the weight to be attached to Mr. Schofield's evidence, which is ground 4 of the appeal, because the judge also said that even if it was admissible, he wouldn't regard it as being of any considerable weight, particularly when set against what he regarded as the clear and unambiguous terms of the settlement agreement. And in our submission, he was right about that too. The evidence is vague, and it doesn't, in fact, contain any evidence to the effect that the parties discussed and agreed that the claims to be settled under the settlement agreement would not include claims against the former administrators or Clyde Co, or indeed that Barclays intended that to be the position. At most, as a matter of objective fact, it establishes the parties discussed and were aware of possible claims against the joint administrators as I submitted. That doesn't help my learned friend. But so far as subjective intent and agreement or understanding is concerned, even if that was admissible, it doesn't in fact establish that there was any agreement, understanding, or intent on the part of Barclays. So even if it was admitted, and we say that evidence of subjective intent, previous negotiations can't be, it doesn't go anywhere. And on that point, we expect to suggest the position of the appellants has got worse since the position before the judge. Before the judge, they didn't have any evidence from Barclays at all. So there was a gap, a complete gap in the evidence. What we now have is Barclays' response to the rectification claim. And if you go to page 478, my Lord Justice Newey referred to this earlier, core bundle, divided 29, page 478. This letter is obviously sent after the judge's judgment has been handed down, in which he has expressed his conclusions as to how the settlement agreement is to be interpreted. And then the third paragraph, Barclays does not consider there to have been any mistake in the settlement agreement. It was freely negotiated between the parties to the benefit of sophisticated legal advice, the issue instead appears to be a question of interpretation. In particular, your clients disagree with the court's construction of the settlement agreement, as set out in the judgment of His Honour Judge Davis White QC, dated 22nd of September 2021. That doesn't provide any grounds for claiming rectification. So they've got the judge's judgment, they've seen what the judge says about interpretation. Their position is they don't consider there to have been any mistake in the settlement agreement. So not only does Mr. Schofield's evidence not actually provide any evidence of the subjective intention, agreement or understanding of Barclays at the time, what we do have from Barclays suggests that they don't in fact share Mr. Schofield's position and understanding. So for all those reasons, we submit the judge was right to regard it as inadmissible so far as it concerns evidence of agreement, understanding and intent. Even if he did allow that in, it didn't go anywhere. And the evidence of objective fact, well, that is admissible, but that is against my learned friend. Well, that's probably a convenient moment. I've just got rectification and ex parte James to finish off in the morning.
So just to be clear, as I understand the timetable, you've got another 20 minutes in the morning.
I think I have. I mean, there's a slight sort of...
Unless you do a deal with Mr. Curl, that's, I think...
Yes, I mean, I don't want to quibble too much. I think my learned friend got the benefit of an extra 10 minutes, but...
I don't think it was 10 minutes.
Was it not? Because he didn't get the transcriber break.
Oh, I see, but
yeah.
You've got the benefit of one transcriber break.
I'm not sure if descending into that amount of detail is probably going to be helpful, so I'll try and get it done in 20 minutes is a short answer.
In that case, we'll break now and resume at 10:30 in the morning.
All rise.